Hi guys, this is attorney Natalia Porsche out of Biloxi, Mississippi. Welcome to my YouTube channel, and this video will be about immigration law and a little bit about constitutional law too. So specifically, I would like to discuss the issue of whether if I'm here on a tourist visa, B-1 or B-2, with my child who has the same visa, B-1 or B-2, can my child attend a school in the United States? So first, I would like to discuss a landmark case, Ply versus Doe. So Ply versus Doe is about, it's a Texas case, and it's about four families who sued the state of Texas over, they alleged that their equal protection rights were violated. They were undocumented children, okay, families who came here to the United States and they sent their kids to school and they were undocumented. So in 1977 they filed a lawsuit against the state of Texas, and they alleged that because they got expelled from school, their children got expelled from school, so they alleged that their equal protection right of the United States Constitution was violated. And guys, it was a horrible legal battle, and it continued for 5 years. So in 1982, finally, the Supreme Court ruled that yes, the state of Texas violated their equal protection rights. They were undocumented, however, because they were here in the United States. And guys, it's very important that Supreme Court actually treated them as immigrant, okay? They call them immigrant families, okay? So I think it's a very, very important point that they were treated here as immigrant versus non-immigrant. So in this case, Ply versus Doe, the Supreme Court ruled that the state cannot deny undocumented children a public education because it violates their equal protection rights. So what happens if your child is here on a tourist visa? Let's say that your child is not undocumented, okay? So at this point, I think Ply versus Doe definitely does not apply to the facts of your specific case. So because Ply versus Doe treated undocumented children as immigrant children, children of immigrant families, versus if you are coming to this country on B-1, B-2 visa and you get treated as non-immigrant. But then it doesn't make sense in my opinion, because what Ply versus Doe stands for, it stands for, okay, we're going to treat immigrant people differently from non-immigrant people. So how do we explain the policy behind this case? Okay, and I know guys, the history of this case is amazing, because so many times people and institutions filed a lawsuit to stop this case from working. Okay, they're trying to put injunction on this case, and all kind of legal actions were taken, but unsuccessful. They were unsuccessful. Therefore, Ply versus Doe is still a landmark United States Supreme Court. So when you come here to the United States on B-1 or B-2 visa, you first, in order to obtain this visa, you go and have your interview, right? You apply for a visa and you get your interview schedule. So during your interview, you express your intent not to immigrate to the United States, and you express this intent to the officer at the United States Consul abroad. I think that's the reason why when you come here to the United States on B-1 or B-2 visa and you have a child with you also who is on B-1, B-2 visa, the child cannot attend a public or a private school. In order to attend a private school even, the child needs to receive a student visa. Okay, so that's the difference. And so when you come to this country on tourist visa, the child cannot attend the public school, because if the child attend the public school and you decide to, let's say, to adjust to a legal permanent resident, in the future it might be a problem because your child violated, and you violated, because you are the parent and legal guardian, an immigration policy. So the answer would be no, that no, your child cannot attend school here in the United States. So again, this is very interesting because according to Ply versus Doe, the school officials cannot, state school officials cannot ask for your child's immigrant status. And so when you're on B-1, B-2 visa, you can, well, you can go to public school and you can apply, you can enroll your child into school. Okay, so according to Ply versus Doe, you can, but according to immigration policy, you cannot, because you might have a problem down the road if you decide to adjust your status to the legal permanent resident. So again, guys, I was thinking that this issue is very interesting issue. The other point that I wanted to raise, if any of attorneys, you guys watching me, I think it's very interesting to hear your opinion. Please drop a comment down below. I will be very, very interested in hearing your opinion about it. The other issue is, let's say if person here on tourist visa B-1, B-2, they come into this country, to the United States, and they, without fault of their own, someone, let's say, negligently hit their vehicle and they're a victim now of the car accident. So can they recover? Well, yes, they can, because they're here in the United States, although they are legally here, right? So they can recover. Undocumented people can recover also. But guys, remember, this is not a legal advice. This is general information. But according to Ply versus Doe, they have equal protection. They are protected by equal protection clause of the United States Constitution. So how Ply versus Doe affect people who come here to the United States on non-immigrant visa? So it almost seems as Ply versus Doe stands for that, okay, well, I came here in the United States on a tourist visa, so, and I don't want to violate the policy, right, of non-immigrant visa, so I will have to become undocumented in order for my child to go to school, so that we do not violate the immigrant policy of non-immigrant visa. So this is very interesting issue, I think. And guys, again, if your attorneys watching me, please drop your comment down below. It will be very interesting to hear from you about this issue. And thank you so much for watching this video. Subscribe to my channel and give me a thumbs up.